Limited liability companies are on a race to comply with the January 31st deadline for registration of beneficial owners with the Registrar of Companies. Legal experts now say that whereas this presents a benefit as far as scrutiny of companies is concerned, there are a number of grey areas which need tightening.
Effective 31st of January 2021, all limited liability companies will be required to maintain a register of beneficial owners and file the same with the Registrar of Companies. This is in line with the October 2020 announcement by the Registrar of Companies, which was made through a public notice following recommendation from the Financial Action Task Force on International Standards on Combating Money Laundering and the Financing of Terrorism. What exactly does this mean for companies?
Well, in terms of implication, it means that look at your shareholders as the first place. Try and see who owns more than 10%. It could be a company. Try to find out who the ultimate beneficial owner is, who owns more than 10% in the company. Identify anyone who has significant influence over the company in terms of voting rights, in terms of appointment of board members. So identify these people, get information about them.
And what happens then should the deadline pass and a limited liability company is not compliant with the provision?
For the company itself, they're talking about 500,000 Kenya shillings penalty for the company and its officers, meaning even its directors could face this particular fine on conviction, and another 50,000 Kenya shillings for every continuing default per day. And then for an individual person, you may wonder, okay, what does it have to do for me? Well, I look at it from a transactions perspective. So if you don't comply, then the company's registry officers at the registry have powers to kind of stop a transaction where the company in which the shares or some transaction is happening has not disclosed who the beneficial owners are.
There is, however, grave concern as to what this means for privacy should the information of companies be leaked from the registry.
I saw a penalty of 20,000 shillings for someone who discloses this information to the public. For example, an officer. Is that 20,000 shillings sufficient compared to, the kind of information that is being disclosed and what someone could do with it?
The Companies Act defines a beneficial owner as, and I quote, the natural person who ultimately owns and controls a legal person or on whose behalf transactions are conducted.